Another state proceed.
They have been there for 3 hours.
We have been there for 3 hours. One can proceed if Jatiko wants to. Let us proceed.
Yes, my lord. My lord, as respondents, we are working as a group, as a team. And there's some information, my lord, which was brought here when we are in court. For example, in respect to the sureties, for which as a team, not as a single prosecutor, we need to deliberate upon before we become prosecutors.
About what?
The sureties and some
The sureties you reply later, but proceed.
My lord, the place will appear here and that we see the stand of 30 minutes. Proceed. Be able to proceed. And it is a submission that we ask for 30 minutes to prepare and
It is my considered view and opinion that we proceed. There are 3 state attorneys in court. Let us proceed. Where you have reservation, point it out. In this presentation. Where you have reservations. Let us proceed. Where there are some things we need clarification, we shall read later.
we have an option to proceed. I would have taken the presentation for the respondent. My lord, this application is primarily based on the activity that the applicants, before you locked mandatory period before they are committed to High Court. And as such, they should be released. My lord, the applicants also raised other issues, other grounds like advanced age, sureties, among others. The respondent shall also make an omnibus response to the two applicants. This application is solely hinged on whether or not the applicants had brought mandatory and whether court can go ahead and admit them to bail. Premise on the prayer on the above the Lord. My Lord, whether or not the applicants are developed mandatory, it is a submission that by the time of committal, on the 29th of May 2025, the applicants had not blocked mandatory. In fact, by the time of filing this application, my Lord, which is the 29th of May 2025, the applicants had already spent 98 days on remand. Days on remand. Yes, my Lord. My Lord, we refer you to paragraph 15 of the affidavit of Detective I.T. conducted Besigye Festo in respect to the first applicant, and paragraph 12 of Detective Inspector of Police who conducted Besigye Festo in respect to the second applicant. My Lord, the applicants were remanded in custody on the 21st of February 2025. And that was the time when the Office of the Director of Public Prosecutions had taken over or had instituted fresh investigations and therefore brought fresh charges against the applicants. My Lord, the applicants were charged with on the 21st of February 2025, they were charged with treason and misprision of treason. true, therefore, that the DPP was in charge of this matter, of the applicant's matter, while they appeared before the General Court Martial on the 20th of November 2024. Much as we acknowledge the office of the DPP is provided for under Article 120 of the Constitution. And under Clause 3B of the same article, the office of the DPP has no jurisdiction over matters that emanate from the General Court Martial. These are two different institutions. Whereas the DPP is under the Constitution, the General Court Martial is a child of the Uganda People's Defense Act. In fact, it is an absurdity to hear the applicants argue that the office of the DPP had jurisdiction over the charges that the applicants were facing before the General Court Martial. The charges in the two were completely different. The charges in the two were completely different. The respondent shall not repeat what the applicants stated about the charges against them before the General Court Martial. But we shall simply emphasize that those charges which we were facing before the General Court Martial are completely different from those that the applicants are right now facing. My Lord, I would refer you to the case of your brother, Honorable Justice Dr. Douglas Karua Singiza, while handling Civil Division Business Cause number 31 of 2025. Number 31 of 2025. As the applicants, we are seeking the right of habeas corpus. My Lord, I just want to go through this DP of Besigye is here, and we are about to highlight it. That is retired Colonel Dr. Besigye and Obed Lutale, Vice Attorney General and Commissioner General of Prisons. Those are the patterns. My Lord, my senior colleague, Honorable Medak Sepona, as he is, submitted as below. That the transfer, that is true, the transfer of the General Court Martial files to the DPP and the civil courts is legally impossible. Since that court had no power to try the applicants in the first place. Just for emphasis, my Lord, what you're about here, my Lord, is my submission. Is that the rationale of that is that whereas the UPDF and the General Court Martial fall under the military justice system, the civil courts fall under the civil justice system. Bundling the two would be a legal error. As if that's not enough, my Lord, my colleague, my senior colleague, Honorable Medak Sebunazi, is continuing that the Supreme Court did not order. He's going to submit that the Supreme Court did not order the DPP to take over the GCM files, General Court Martial files. Because doing so would infringe the constitutional provisions in brackets under prosecutorial powers of the DPP. My Lord, that view was also echoed by President Lord Mayor Elias Ukon, Counsel for the Applicants. Now, in that application, my Lord, allow me both directly and both verbally what the judge had to say. He said that, as understood by this court, the applicant's position is that To the extent, and remember this is on page 10, that to the extent that a Supreme Court decision nullified the power of the General Court Martial, GCM, to try them. They remain in illegal detention. Because they are no longer lawfully detained by the prison authorities. And no longer lawfully detained by the prison authorities, and cannot remain in illegal detention. On account of the uncertain administrative processes that seek to implement the Supreme Court's decision. Besides, all previous cases before the GCM, General Court Martial, had equally relapsed. And could never be resurrected by the DPP. Because, my lord, this is very interesting. Because doing so would be constitutionally improper. He further stated that under Section 56 of the Evidence Act, Cap 8, Section 56 of the Evidence Act, Cap 8, this court is enjoined to take judicial notice of the proceedings of 21st February 2025 in the Chief Magistrate's Court of Nakawa at Nakawa, in criminal case number 285 of 2025, in which the applicants were formally charged in the course of law and remanded. While the court would have wished to answer the issues raised the issues raised, it would be moot for it to do so. The application was dismissed. My Lord, these were the arguments of the applicants in that application. it shouldn't be them right now. Having spoken English in the other application, then they speak Chinese in this one. What do I mean? To change goalposts and then submit that there was a transfer of the cases from the General Court Martial to the Office of the Director of Public Prosecutions and the Judiciary. By arguing so, there will be a possibility of actually misleading this court. It is an improper interpretation of Article 120 of the Constitution in terms of the roles and then the jurisdiction of the court martial. My Lord, I appreciate the fact that this ruling, my Lord, is persuasive. However, we invite you, my Lord, to take judicial notice of that and agree with that as the proposition of the law. If you, my Lord, agree with the respondent that that is the proper position of the law, then the argument by the applicants, my Lord, lacks merit. It is misplaced, and it is irrational in one way or the other. And if, my Lord, you agree with the respondent